Have you ever thought what drives the leaders of multinational corporations to make crucial business decisions that led to the success of some of the notable deals in the Philippines? Or what causes the breaking of potential mergers and acquisitions? This is Prime Movers, a legal podcast that covers the latest and relevant trends and insights on Philippine legal issues and topics, expertly discussed and diluted down by the experienced legal team at Gorriceta Africa Cauton Saavedra. Again, this is Prime Movers. For our 8th episode, we have our very own Atty Kristine T. Torres, Junior Partner at Gorriceta Africa Cauton Saavedra, who will share with us her knowledge, experience, and insights about mergers and acquisitions. In particular, Atty Kristine will talk about her learnings and experience handling multiple M&A deals and the importance of conducting due diligence for these kinds of transactions.
Hi everyone and welcome back to Prime Movers. This is Shai Season, a counsel at Gorriceta and a member of our firm's taxation group. In this episode, we are going to talk about a very interesting aspect of mergers and acquisitions. Joining us for this episode is a seasoned corporate and mergers and acquisitions lawyer who specializes in this field and has extensive experience in mergers and acquisition transactions, both domestic and cross-border. She has been shortlisted for 2 consecutive years for the Young Lawyer of the Year category at both the ALB Southeast Asia Law Awards and the Philippine Law Awards. She is also consistently recognized by the Legal 500 as among the next generation partners in technology, media, and telecommunications practice area and a recommended lawyer in several other practice areas such as corporate and mergers and acquisitions, banking and finance, capital markets, and projects and energy. Let us all welcome Atty Kristine T. Torres. Hi, Kristine.
Hi, Shai, and hello to all the listeners of Prime Movers.
Thank you for joining us today, Kristine. And as mentioned earlier, mergers and acquisitions is among your specializations. Can you share with us a bit of background into your M&A journey and exposure?
Thanks for having me, Shai. And yes, I've been practicing mergers and acquisitions and corporate law for most of my career. I have handled and specialized on asset and share purchase transactions involving both private and publicly listed companies in different sectors like education, health, energy, retail, banking, finance, and lately a lot of tech. In these deals, I represent either the buy or sell side parties. And I've also been very exposed in a lot of cross-border M&A deals at the firm, working closely with foreign M&A lawyers and transaction advisors, either on a limited capacity for local due diligence work or end-to-end acquisition and buyout transactions.
That sounds exciting, but it also seems like a lot of heavy lifting and complex work is required. It's good that you highlighted your due diligence experience since, as most of us lawyers know, it's a critical part of most business transactions. But to further expound, and of course for the benefit of our non-lawyer listeners, what exactly is due diligence in the mergers and acquisitions context?
Okay, so in a nutshell, due diligence is a process of taking well-informed steps through careful review and verification before committing to a commercial transaction with the objective of avoiding a bad outcome. In the context of mergers and acquisitions, let's say there's a buyer who wants to acquire a company or even an asset. This buyer would, of course, want to know and understand what it is buying into, what is the target's real value, what are the add-ons to its acquisition, the liabilities, obligations, and risks that may impact the value, and the extent that it can become liable in the future. And this is precisely what due diligence does. It helps discover the facts, the information, and risks that both parties, and not just the buyer, should be aware of.
And this due diligence process, what aspect or aspects of the target company or asset does it actually cover?
The due diligence process covers all aspects of the target company's business, or for an asset purchase, all information relating to such assets. These are covered by different types of due diligence. So we have financial, legal, operational, tax, intellectual property, commercial and business due diligence, and for some types of transactions, ESG and cybersecurity due diligence. However, sometimes the buyer also has the option to limit the coverage of the due diligence depending on its priority, its risk appetite, or sometimes timeline considerations.
Oh, wow, that sounds like a lot. And do you handle all those kinds of due diligence?
As an M&A lawyer, I cover legal due diligence, and this extends to review and analysis of the organizational and corporate documents, the shareholding structure, contracts, loans and liabilities, litigation, tax records and filings, permits, licenses, intellectual property, and environmental laws, among others.
Okay, so we've been saying that due diligence is important. But could you contextualize this? Perhaps give us a more concrete basis or picture on why this is actually important?
I always tell our clients that to get the full picture of all the benefits and risks of acquiring a company or a specific business or even an asset, conducting due diligence and doing so before signing off on a deal is vital. For buyers, it of course puts them in a better position to make informed decisions and in identifying early on the potential risks of acquiring the target. It enables them to really have a good sense about the target's business, understand its operations, the revenue income streams, the potential synergies and scalability of the business, and the expense and liability exposures, which then aids them to determine the fair value of the company and later on the purchase price. Ultimately, it also aids in risk management and mitigation, which are both crucial in preserving the target's value.
I'm just curious. Earlier, you mentioned that due diligence helps both parties and not just the buyers. We all understand how this actually helps the buyers, but how is it beneficial to the sellers?
Diligence also benefits the sellers since it enables them to gather and confirm information they already have that would be relevant in valuing the deal.
Could you elaborate on that, Kristine?
Definitely. So, from a seller's perspective, Shai, of course, one of the main objectives would be to optimize the value of the deal and ensure that they get the highest price possible, right? Doing some preliminary due diligence and, knowing the skeletons in your closet, ideally before the buy-side diligence commences, helps the sellers achieve that objective. Through this process, they are able to identify upfront the issues and red flags before the other party catches them and consequently compromise the deal. Catching these issues and red flags early on allows the sellers to correct or address the gaps. Sell-side due diligence can also help make transactions smoother and faster since it helps prepare the company for a potential acquisition and for the sellers to present a clearer and more credible narrative. And by knowing your strengths and weaknesses, sellers are more able to position the target company in a more accurate manner and avoid having surprises later on that could derail, delay, or even break the deal. Think of it as a rehearsal or dry run, where you will be able to spot which parts needs to be polished, changed, or removed to make it viable for potential acquirers.
Okay, so based on your examples, it looks like diligence is only done to check the target company or assets. But are there actually instances where the buyer is also the subject of due diligence?
That's actually a very good question, Shai. So in most cases, sellers would also want to conduct due diligence on the buyer to help in deciding whether entering into a deal would be beneficial from a financial, reputational, and in some cases, timeline perspective.
Thank you for that, Kristine. So now that we've established how due diligence benefits both the sellers and the buyers, can you share with us your approach in conducting due diligence?
Well, the approach would really depend on the type of the deal, the size and complexity of the transaction, the parties involved, and of course, the risk profile, tolerance, and background of the client. There is no one-size-fits-all strategy for M&A transactions. If I'm representing the buyer, What I do is first determine the purpose of the acquisition, because there is a strategic acquirer and a financial acquirer, and each type has a different set of requirements and considerations which sometimes affect the approach on due diligence.
Oh, wow, that's really interesting. I actually didn't know that. I guess, as lawyers, we still kind of learn something new every day. Can you explain further the difference between the two that you just mentioned?
Strategic acquirers are more interested in aligning the business with the target's operations or revenue drivers. And the business and commercial due diligence here is sometimes streamlined due to familiarity of the business, the industry, and operations. The primary focus here is potential synergies and integration capabilities, and how it will all tie up post acquisition. For us legal advisors, this often means more focus on other key factors such as the review of the ownership and asset documentation, corporate governance, antitrust issues, contractual red flags and liabilities, even labor and employment law, and other issues that have long-term implications to the acquirer. Financial buyers, on the other hand, are generally the private equity firms and investment funds whose main concern is the financial returns out of the transaction. So in terms of due diligence, the review is more demanding due to lack of intimate knowledge of the business, and it will also be heavily focused on examining the target company's financial records and performance. For purposes of risk identification, the ones that are relevant would be those that impact the valuation of the target and financial returns.
Okay, I understand that the considerations you mentioned are, to some extent, dictated by industry practice and standards. But do legal advisors also recommend which matters should be the focus of a due diligence? I guess especially in cases when transactions have a short timeline.
Actually, I also try to determine upfront what is important for the client since this helps streamline the process. And this becomes especially helpful for deals that have very short window for due diligence because knowing what is important for them and having an idea about their post M&A integration plans would really help in determining the key diligence issues that should be highlighted.
I also recall that you mentioned earlier that the parties involved are also a consideration when it comes to the diligence work. What do you mean by that?
I would say that the industry where the target company belongs to is also a factor in strategizing for due diligence work. Of course, the due diligence required on a bank or a company in the financial industry is not the same as the due diligence for, let's say, an energy company or a tech or an IT company. The considerations and areas of focus would be different. There are transactions that, require a more extensive due diligence. And an example would be a target company that is highly regulated or has secondary licenses or one that is imbued with public interest. What this means in terms of due diligence approach is looking more closely into the specific area of concern, like the licenses and the regulatory compliance of the target company, especially if the licenses are the main value drivers for the acquisition. And just to add, due diligence approach is also different if the structure is an asset sale or one where there is a share swap component, or if the target company is public or a listed company. Since in these cases, you also have to consider the structure and evaluating the risks, identifying the materiality, and ultimately in determining how to manage the risks from a documentation perspective.
Wow, that's quite a lot, Christine. Thank you for sharing your valuable insight. Now, what about red flags? Since we've talked about issue and risk identification in your experience, what are the usual red flags, or I guess to phrase it differently, what were the biggest red flags you have come across during due diligence?
You have to keep in mind, Shai, that issue spotting when you are the buy side counsel would depend on the main considerations of the buyer in acquiring the target. Of course, there are usual due diligence concerns like potential litigation or tax issues, or for family owned businesses or startups, we often see the usual problem of not having professionalized way of doing things, which means lack of documentation or housekeeping related issues. And as far as legal due diligence is concerned, the common ones that we have uncovered are the legal and compliance issues, potential revocation of licenses, tax exposures and liabilities, related party transactions, and in some cases involving multiple sellers, issues surrounding the deceased shareholders and their estate settlement challenges. But then again, in identifying the kind of issue that would influence the buyer's decision to walk away and kill the deal, this would really go back to their purpose for the acquisition and deal considerations, and may also be impacted by things like deal structure or the party's timeline considerations.
I understand from what you have shared earlier that diligence mostly helps parties manage the risk and, as much as possible, find ways to make the deal happen by addressing the issues from documentation perspective. But have you ever experienced uncovering a red flag that was actually a deal breaker? I guess one that made the buyer walk away?
Yes, unfortunately, we have a number of M&A deals that fell apart due to diligence issues. We also have encountered deals in the past that didn't push through because of trust and internal shareholder disputes, for example, that are not easily addressable in deal documentation due to deal structure. And that deal involved an acquisition of a minority stake where the corporate buyer was primarily focused on synergistic opportunities as a strategic buyer and, of course, corporate governance. We also have an ongoing transaction now, which we are still hoping to close, even though there are shareholder disputes and boardroom and court drama that have greatly impacted the timeline as we speak. And this may potentially even kill the deal if it doesn't get resolved. Of course, there are a host of other issues that we flagged during the due diligence, but this litigation issue and the dragging court battle are the major ones. In another deal that I handled, the main objective there was to acquire the target company because of the licenses it possesses. So naturally, the fact that there were material issues on the license status and compliance, which we have uncovered during our due diligence, was the main deal breakers for our client. For the vast majority of the deals where we represent financial buyers, one of the material issues that caused the deal to fall apart was, of course, the financial and valuation issues and accounting practices of the target.
Okay, with all these in mind, are mergers and acquisitions still advisable? And if so, how do you encourage entities to still involve themselves in M&A deals?
I'd like to say that with the right kind of deals, M&A as a growth strategy still offers a lot of benefits to corporate acquirers. It could mean greater financial strength for the companies involved in the transaction and diversity in a company's portfolio where a wider range of services or products may be offered. I will leave the deal acquisition and integration strategy tips to the experts, but in terms of deal execution, obviously before entering a deal, you want to make sure that you have the right team to assist you. And I'm not just talking about financial advisors or legal advisors, because depending on the type of industry or complexity of the deal, having your technical team, if the deal involves technical issues, ESG advisors, for example, especially if there are environmental implications, and your integration team during the entire process is crucial.
How are M&A deals doing right now?
In general, I think the M&A space is recovering from the pandemic. In fact, the Philippines ranked 83rd in the 2022 Global Opportunity Index. Global M&A activity has climbed sharply since 2021, creating more opportunities in emerging markets like the Philippines. And the Philippines even became more competitive and attractive as a global destination for business combinations against its neighboring countries.
That's great, Christine. And how do you see M&A deals vis-a-vis the due diligence process this 2023?
With the developing trends in M&A comes the changes in conducting due diligence. The Philippines may soon adopt to the new areas of due diligence because based on my observation, Globally, investors are starting to focus as well on due diligence on ESG or environmental, social, and governance. This may still be covered by legal due diligence since it has its legal component as well. But in time, we might be able to adopt to what the UK government is pursuing, like the climate disclosures, wider environmental sustainability, boardroom diversity, and supply chain ethics. We might also take into consideration adopting the practices in Spain, where companies are required to prepare a detailed gender pay report or even provide COVID related support schemes. But without a doubt, M&A deals are shaped by due diligence considerations, old and new, and as such, companies or regulators, even advisors and councils must learn to adapt to these changing times.
Right. And that's a wrap for our eighth episode of Prime Movers. Thank you very much for your time and for your valuable insights, Christine. And I'm sure our listeners have a lot of key takeaways from our conversation today.
Thank you again, Shai, for having me.
In our next episode, we will be talking about the impact of and compliance and regulatory reporting requirements related to data breach and the best practices for businesses and individuals in protecting data. Make sure to catch it. Once again, this is Shai Season, and thank you for listening.